is to put the idea behind any exit clause is to push the startup to achieve a certain level of scale and grow to intrinsically generate value for all stakeholders of the company, right? Including the investor. The founder should not be made liable, personally liable, I would say, to pay up to, whatever it is, 3x or 5x of the investment amount if the company has not reached that point yet, right? So while most of you might be already incorporated as a private limited company, I would say that's a step, while it's a step in the right direction, I have seen founders not basically understanding the real advantage of incorporating a private limited company, having a separate legal entity, right, and using it to their own gain in negotiations with either investors or any other third party. That's a bit about separate legal entity, right? When it comes to board processes, I would say that the board of directors is by far the most integral part of a startup's internal management, right? The management structure. A company's strategic direction is almost entirely dependent upon, the decisions taken by the board. Now, these decisions may range from anywhere like, the significant ones would be basically like, okay, we are about to raise, a round of funds, right? Hiring and firing of, C-suite executives, right? Budgets, or how about if we open up a new product line, right? So these are very, very integral or very, very key aspects that are basically decided by the board. The legal requirement for a private limited company under law is that it should at least have two directors on its board. Directors are subject to a few fiduciary duties also that we would talk in, a bit from now. These duties are nothing but, what kind of things matter when you are acting in the best interests of the company, right? And this in some way or form also is connected with the what is a board required to do. It's supposed to dispense its fiduciary duties, right? And I'll talk about it when we come to it. Who composes the board, right? Usually the early founding team members compose the board, right? But this is a moment when I would also want to take a minute or two to talk about, the distinction between executive directors and non-executive directors, right? These are two types of directors that compose the board, right? Executive directors are people like you, right? They are actually founder directors. They are the people who are working as, or who are founders in the company, right? Non-executive directors are an example of that would be nominee directors, right? Nominee directors are typically the ones that are being appointed by the investor, say, for example, or they are independent directors, right? Independent directors are directors that you may end up onboarding, say, for example, during your growth stage, right? For strategic purposes, or when you want basically mentors, right? So the reason why this distinction is necessary is that, executive, as the name suggests, they are in charge of the day-to-day operations of the company. Non-executive directors are not, right? But still, Companies Act places the same amount of liability, right, on both of them, right? If you want to know that what stage should you look for independent directors, right? When is it, the right time to get independent directors, such as, mentors to your board or otherwise, or even generally, for any kind of strategic decisions, I would suggest that, I write routinely a lot on the legal aspects and, aspects that are crucial, topics that are relevant in the startup space. And you can go onto my LinkedIn profile and you'll find some of those articles handy. About the how, usually most of you as founders would already know this, but board is legally required to meet at least 4 times a year, right? So under the law, technically speaking, no two board meetings can be more than 120 days apart, right? You must also know that sometimes shareholders can requisition a meeting also, right? Requisition meaning demand that the board meet. Why? For instance, a very powerful right under the Companies Act is given to the shareholders to remove directors, right? For which they can demand a board meeting and move that motion that we want a certain director to be removed. Right? Why is this important? It's important for you to remember this, that eventually, as and when the company grows, as and when it becomes big enough, uh, turns out that you have lost a certain stake, because you would have to dilute as and when you actually give off equity for your funding rounds, right? If you lose majority shareholding in the company, and if things somehow just the way that they are not going very well for you, it is possible that other shareholders may successfully group up and actually requisition a meeting of the board to remove you and have you fired, right, from the very company that you helped build. A very recent example of this has been Anupam Mittal's case, right? He held about 30% stake in his own company, and he was removed as CEO and MD of his own company. Other founders, if I'm not wrong, held about 25 odd percent in the company, and the investor Westbridge held 44, right? And they were successful in ousting Anupam from the position of CEO, and he had to leave, right? So it's very important to understand that it's okay to know that administratively these are the frequencies in which the board meets, but at the same time to be aware of the fact that there are some crucial rights even also given to the shareholders of the company, which when exercised can actually mean um, you know serious consequences, right, for you as a founder or for you as a director in the company. Fiduciary duties. Fiduciary duties, as I said, these are basic duties that are prescribed under the Companies Act as something that most directors would actually, all directors for that matter, are required to perform. And that has to be in the best interest of all the stakeholders. And with stakeholders, the Companies Act has also gone to the extent of including community members, right? Even the environment for that matter. To give you an example, fiduciary duties include duty of care, duty of loyalty, to be diligent, and to exercise independent judgment. The reason why this aspect of fiduciary duty has gained importance in the recent years is that there have been cases where directors have been proven to circumstantially know a few things, but have not acted upon it, right, in the interest of the company, and therefore have been found guilty, right? So imagine some situation where you knew of a wrongdoing. The fact that you did not take any action on it, which means that you omitted, or your omission could actually also prove you guilty in the eyes of law, right? Just for context, a director can be fined a minimum of 1 lakh to a maximum of 5 lakhs under the law for breach of fiduciary duties, right? Now, of course, breach of fiduciary duty is not just limited to any kind of financial or monetary punishment only. It also includes imprisonment in certain severe situations. Again, this is not meant to actually scare you. As I said in the beginning, it's something that my intention here is to help you understand that each decision, everything that you do within the company, if you're doing it from the point of awareness, it is, your odds are much better than the others, right? So basically, in extreme cases of criminal breach of trust, right, misappropriation of property, converting the property for its own use. Say for example, like, a common case is that you can't actually buy a Mercedes, right, with investors money. You cannot convert stuff that is actually meant for the growth of the company for your own use, right? So if there is a criminal breach of trust case against you, you could be imprisoned, right? And which is why there is a lot of importance or legal jargon used in definitive documentation to show that you cannot misappropriate the investment amount that you get from the investors, because as directors you have the fiduciary obligation to use it in the best interest of the company and in the interest of all stakeholders. Last but not the least, control, extremely important. I'll just like take a minute here and tell you that like most cases, there are two ways of approaching this concept. I like to say that there are two types of control. One is positive, the other is negative. Positive is when, I would say, you use your shareholding to take decisions, right? You're using your stake in the company to actually take decisions. Negative is when you enjoy a few rights in the company, right? You are entitled to to a few contractual rights in a company, such that those rights allow you to restrict the company from taking certain decisions. There's a difference, right? One is by way of enjoying majority in the company, you are able to take some decisions, right? Because you are the shareholder who has the most stake in the company. The other is when you might not be holding as much in the company, but because there are a few rights that you have agreed to under a contract with the founders and the company, that you can now restrict the company from taking a few decisions, right? So for those of you who have already either raised funds would know this, and those who haven't, I would say that there's something called as reserved matters under your definitive documentation, right? These are matters that you cannot decide upon without the prior written consent of the investor. So you may think that you would have probably given 10 to 15% out to an investor, but the ability to take these decisions reserved matters are a list of matters, a list of decisions that you cannot act upon without the prior written consent of the investor, right? So sometimes founders find it extremely tricky because for small things also, there is this administrative aspect of going, taking their consent, taking it in writing, and then acting upon. And that's also control, and which is something that that distinction is what I wanted to highlight here. That you might think that it's not, a function of only and only shareholding in the company. You might be giving out very little, but there might be contractual rights that might not be favoring you. Next, I want to talk about a very important aspect, which is equity allocation. Why is this important? Well, if you are two or more founders, this is definitely important because you'd have to find a way out to, make this entire pie or divide this cake in a way that is fair and equitable, right? While most of you probably might have crossed this junction or like, this phase of making this decision. Some of the things or high level things that I want to highlight is, execution is always going to be greater than the idea, right? This is something that I tell my founders all the time. These are aspects that, if not with respect to deciding the equity split, this is a concept that will help you in deciding a lot of other crucial aspects of building a startup, right? I feel that, genuinely speaking, ideas have zero value. A lot of founders give a lot of importance to who came up with the idea. And, of course, I mean, at the start, to begin with, ideas are important, but not without execution. And so you need to resist the urge to give a disproportionate amount of importance, to the fact that whoever came up with the idea deserves, more or better equity in the company, right? And then the obvious question that I'm faced, or like that I'm asked, mostly, is that then how much equity should be allocated to each founder? Should we split it equally, right? Well, in an ideal scenario, I would say yes, because even to an investor, an equal equity split shows trust, it shows commitment, it shows, the clarity in terms of expectations, right? That you have from the future of your startup, right? But I often also encounter companies that do not have an equal split, an exactly equal split, which is also fine as long as the split is not, very disproportionate, right? To show that, okay, somebody is holding only 20%, the other one is holding only 80%, is holding the rest of 80%, right? It should not be that skewed also. Thirdly, it is really important to look forwards and not backwards when you are evaluating how the equity should be split, right? And the reason why I'm saying I'm giving some time to equity split, despite knowing that a lot of you might have already, taken this decision and moved on, is because, even after that decision has been made, I see that a lot of founder disputes arise from, how are the shares going to be split? If the shares have been split and if someone leaves abruptly, how do I ensure that it comes back to the company, right? At that time, right, it is important to know that what is the goal here, right? Where is this going? And which is why I say that when you're deciding upon these kind of matters, it is really important to look forwards and not backwards, especially when, your ideas may change, right? Startups basically pivot from their original ideas very often. It's very, very normal to actually see that, they were working on a certain line of, thought, and now they have changed, right? But if the expectation among the founders is that, you know you're clear that you are in it for the long haul, everything is, whatever we build for the company is for the future, then, everything that happens before this point, that you are, deciding that how to split the equity, what to do with it, how to actually like cope up with any kind of adversity of, having a founder dispute or what, it is not going to matter, because both of you would actually have, or whatever number of founders there are, there's that clarity that we are there, we are building for the future, and this is something that we are going to keep on doing. And which is why all the ideas, all the leads that we have been that I or that other person has been able to come up with, would not matter and should not matter. It doesn't matter who came up with the idea, who brought in the first customer, I had once a company, a founder who actually demanded more equity just because he made the first few introductory calls with the investor who eventually got interested. Right. So, and point is that if you are looking forward and not backwards, and the idea is only to actually execute and build for the future, it's not going to matter that how much equity, how much how what is the equity split like. Of course it has to be equal and fair, um, and the whole team is obviously necessary for execution, right? Even the person who's having slightly lesser equity in the company also is not, it's not like that his or her contributions are not important, right? You need the whole team for execution. So the next thing we are going to talk about is vesting. I believe most of you already know what vesting means. But just for clarity, I would say that vesting is the right of owning your own shares, right, in your startup over a defined period of time. If you leave before the vesting period is over, the company can get the unvested shares back. Right? That's the concept of vesting. Now, why is this important? Well, as you approach fundraise, most investors would ask for this, right? When most investors would ask for, the vesting part in the definitive documentation, or they would expect to see that vesting clause in your founder's agreement. Right? You need vesting the most, as I said, previously talking about the fact that what happens when a founder abruptly leaves, right? So you need vesting the most when a founder leaves the company, right? When he or she leaves, a huge chunk of equity would leave had there been no concept of vesting, right? Obviously, if that person leaves with a huge chunk of equity, that's not going to be fair for the other founders who are left behind. In addition, I feel that vesting also incentivizes founders to stay with the company, right? And keep working on their idea, because if a founder can, just one day leave and take their shares with them, why would you stay and continue slogging and keep building if from day one you already had their shares vested in them? Like, if they already had no concept of vesting, and if the shares were already like with them, they could just leave, and you'd be left with your share, still slogging and still chasing growth, right? Having said that, the other question that generally people, like with people who start the company all alone or are solo founders, the question that I get asked a lot is, should solo founders be tied to vesting? Do they require vesting also? And I would say yes, they do. This concept of staying incentivized works even for single founders. Incentivized, as I said, means, staying with the company for long enough to actually help see it grow, right? You are incentivized because, say, for example, if you are holding 45% or 50% in the company and you're two founders, then that quarterly or annual vesting that comes to you year on year actually keeps you grounded and keeps you, persistent in your efforts to, make the company or, push the company to the next milestone that you have thought about, right? And which is equally true for solo founders. It sets an example also for your future employees, because when you create what you call as an ESOP pool, the shares also vest in employees over a period of time. So if you did not have any kind of vesting concept, it's like asking your employees to undergo the vesting, which is basically the idea behind an ESOP pool, right? But the same thing or the same idea of vesting does not apply to you, right, as a founder. So it's really a culture point at this time of growth cycle or phase of your business, that what kind of culture also you want your company to have, right? So something that is applicable to employees, when employees see that there is transparency and there is parity in the way that even founders are working, right, vesting also is applied to them, then is when they are more encouraged to actually accept this idea of vesting and get some or the other kind of options in the company. Compliances with fundraising, I would say this is something that comes in later, but something that you should know, which is that usually these are the set of compliances that you would have to go through. Either your company secretary would educate you about it, but basically what happens is that the first thing that happens is that you would need to increase your authorized share capital, right? Why is this important? Most companies, most startups that start with, they start with a very, very tiny authorized share capital because they just want to get the operations, they just want to get the business, started. And which is why, say, for example, the authorized share capital of your company is, say, just 5 lakhs, right? But the investment amount that you have recently gotten, or, the term sheet that you have in front of you says that I want to invest 1 CR, right? So obviously, if you're authorized to only have like 5 lakhs, you cannot have 1 CR as an investment amount, right? Which is why the first thing that Companies Act allows you to do is that do the process of increasing your authorized share capital. Private placement usually happens as you basically, private placement, as the name suggests, is the process of privately placing some of the shares of your company, right? Why is this important? Because mostly when you are going for fundraise, the way that you would be raising funds is through private placement, right? The process that you'll be adopting under the Companies Act is called private placement, right? So just to let you know about these terms, there are several forms like pass 4 and pass 5 that you'll be required to sign, and there are return of allotments and all of those things that go to the MCA. A very important thing that happens is that when you are raising funds through private placement, you will have to open a separate bank account, right? This is something that a lot of people don't know. They think that no, our company already has a current account, we already have a bank account, why do we have to open a separate bank account? Well, it's the requirement of the law, that's why. Right. Amend articles of association. Articles of association is nothing but the constitution of your company, right? The direction and the basically the powers and the rights and the obligations. As our country has Constitution of India, the constitution for your startup is the articles of association. And which is why a lot of investors would actually even want that their rights that they have in your company are also part of the AOA, which is the Articles of Association, right? So eventually you might have to do some process to even amend your articles, for which, of course, there is an entire process, some board meetings, resolutions, shareholder meetings, and so on and so forth. Moving on very quickly, I just want to talk about 3 types of key contracts that initially or early on, you should have as a startup. The reason why these are important is that you'd be aware that there's an entire process of due diligence, right, that an investor undertakes when they decide to actually invest in your startup, right? So due diligence is nothing but the ability or the right to actually go through some of the most intricate details of your company and the way that you have built it, with with a lens of scrutiny, for the amount of liability or the risks that the investor is going to take. Right. So he or she, the investor, wants to know that what kind of risks exist in the company, which I'll be, bearing also by virtue of investing my money in this company. At that time of due diligence, most of the founders have nothing, to actually tender or to actually give to for their review. The reason is that they have never paid heed to some of the most foundational things, one of which are these types of foundational documents, right? If you have nothing to present in your data room, what will the investor do its due diligence on? Right. So to start with, I usually suggest founders to have these set of documents at least, in place, that helps generate a certain kind of trust. Founders agreement more or less is nothing but, as the name suggests, I like to call it as the shareholders agreement before an investor steps in. So consider 2 or 3 shareholders who are founders themselves, who enter into an agreement to understand each other's roles and responsibilities, uh, govern a few situations like departure of a founder, and try and limit the risk of, letting your IP be out or be shared. Like, how do you protect your IP? So consider it to be a shareholders agreement, which is nothing but a founders agreement, because before an investor steps in, you guys are the founders of the company and you guys are the shareholders of the company. So founders agreement would basically deal with these kind of things. I'm recently advising, like currently advising a company that has this situation of departure of a founder. And the one thing that they need the most assistance in is that how would the shares return to the company? Right. Thankfully, it's an amicable separation. And which is why, it's not like the founder does not want to tender his shares, right? But there is a certain level of complexity involved, because you cannot have someone forced to sign a share transfer form and get the equity back, right? And these are the situations when the first document that anyone would refer to is your founders agreement, because that's the agreement where it would be prescribed that in which situation, at what price, who will buy those shares back. Right. So these are the reasons why founders agreement is important. Protection of IPs, of course, is very obvious, right? Whatever you do at the time and the resources of the company, how adequately are you wording it to actually say, to actually mean that everything that the founders do on the time and for the, augmentation of the idea is the IP of the company. Confidentiality and IP, just extending to, or like, double clicking on the last thing that I just spoke about. It's very, very important that you document IP, right? I was working with a founder who already had 3 patents to his name and was now becoming a co-founder in a startup. Right. Now imagine if there is a clause in the agreement that says that everything, all the IP, right, in this domain belongs to the company. It's kind of unfair to that founder, right? And which is why we usually have this kind of agreement wherein for my clients, what I do is I actually prepare a separate annexure that documents past IP, right? IP that they have already created in their own name and they are the inventors for, and creating it as an exception, right? Carving it out of the IP that is owned by the company or by the startup. Applicability to past activities, I would say this is very important, because there are often those situations where, you and your friends start out in dorm rooms, right? Like you're students and you are basically, the company is not incorporated yet, and you started building something, right, on your own laptops, on your own, in your own, time and the resources that you had. how do you make sure that that also is part of the IP? Because that was something, say, for example, the initial code that you wrote, right? Which is just, you're building upon that now when the company is incorporated. But what about that has already occurred in the past, right? So to make that also part of the company's IP, you sign this kind of agreement. And last but not the least, assignment of inventions to the company, right? You There's like, I mean, it's obvious that whatever you do, if there is something that you have created as an IP, uh, uh, even though you are the inventor, an agreement like this in place would say that all of the inventions that you create would be assigned to the company. A very important phrase that usually you would see if you are people who have already been in, past employment with other organizations, you'd see this phrase very often, which is works made for hire, right? It's nothing but the fact that, whatever you do at the in the on the time and resources of the company basically is something that is owned by the company, right? So this is a very important agreement, especially in the early stage for companies to, or for founders to have. Employment agreement, again, people would consider it to be very, very obvious and would not give that much importance. But trust me, there is a, founder that I'm currently assisting. He's almost like raised his Series A, and turns out that now he is willing to actually change the way that his employment contracts look, right? Why? Because there are these nuances that they do not think about in the initial stages of building the company. Say, for example, performance standards, right? So employment agreement, as you would agree, usually has what scope of duties, compensation, and other details like what other benefits you're going to get, right? But what about the fact that, there's an employee who comes to you and says that, look, I was hired to do this, but I'm now also doing this, and my compensation is not basically taking that into account, right? So key employees or your senior manager, or your, like, say, for example, sometimes employees that are very critical to product development and growth should know that their employment is subject to policy decisions of the board, right? Which may change from time to time. So today you probably might be doing product development, the product like the back of your hand, but because you know it, you are also supposed to look after, say, for example, customer success, right? So that's a completely different role. But as long as there is a clause in your agreement that supports that kind of flexibility, you'll always be better off, from any kind of claims or disputes that may happen in the future. Last but not the least, an employment agreement. I would say that with COVID, there's a lot of, like, drama around like moonlighting, right? There are a lot of people who are not on exclusive employment with the startup. And it's very, very important that you have it written somewhere that not just founders or, the key founding team, but also with key employees, they should not do the same type of business on a consulting basis or otherwise, but have exclusive involvement with the startup, that they are in. NDAs, as you would know, generally it's the risk that we are, intentionally going to misappropriate any kind of IP. You don't want any kind of relationships to be compromised with third parties, and which is why you enter into NDAs. While that is common, I see that founders generally want to just like copy paste NDAs from the internet. They'll just like, type in something, and the first thing, or probably if you are a little bit more persistent and hardworking, you'll actually go to the fifth search result also, and you'll try and compare and then get, something cooked up. As a lawyer, I would say that's a very, very bad idea. Again, I have written an article on this on LinkedIn. If you'd like to know that why you should not copy paste an NDA, and the repercussions or the consequences are pretty serious. Right. And why is that? You can go and, check out that article. A lot of people ask me that, a lot of people actually have an investor also sign an NDA before pitching. While that is okay, uh, you know, in some circumstances, I would say that usually, investors don't take it in the right stride. And which is why you have to be careful about what stage are you at, what kind of things do you want to protect, and why do you want an investor to sign an NDA. Legally speaking, it places significant amount of restraints on a professional investor, which I believe that investor would be spending a substantial amount of time, right, evaluating your business and identifying potential investments within a defined industry, right. In a way, they'll be failing in adhering to their fiduciary duties of their own portfolio companies if they sign hundreds of NDAs like this, right? Because signing an NDA with you would create conflicts with the companies that they are actually candidly offering advice to. But at the same time, I also understand why founders would want it or would want to sign NDAs with the investor. At which point I would say that, you can create exceptions to this generic rule that do not sign NDAs with the investor when, in special circumstances, you're covering highly. So, there are times when for the second or the third meeting, you are going and meeting the partner, right, and pitching to the partner of a VC firm, and now is this detailed deck, right, that you are taking in, disclosing a lot of core IP and highly confidential information, right, specific IP that forms part of your, company's core value. And that is when probably you can actually sign an NDA and go ahead. But otherwise, I would say that, legally speaking, it puts an investor into a lot of, like, fuzzy territory. And at the same time, to a professional investor, it screams your mistrust, I would say. But in certain specific situations, I would say that it's okay to actually, like, get an investor sign an NDA. Very quickly, IP is very important. As you would know, that it improves valuation, kind of gives you a certain level of reputation, builds a competitive advantage, and eventually helps you generate a revenue stream also. Why? Because, say for example, patents you can actually license, right, and earn a licensing fee out of it. The reason why I want to take a minute to talk about patents is because people feel that only an end product can be patented. But as you can see, under the law, even process or methods, right, they can also be patented, right. Very recently, I had a founder come to me, based in Goa, and he tells me that there's a certain kind of miso that he is developing, and that sauce, I want to get a process patent for the way that it is made. Right, very interesting. But basically, it comes from the point of awareness that whether or not something that you are working on can be patented or not, for which you need to know that the art and the process and the method of manufacturing can also be patented, right. And the first thing that a lawyer, or what we do for our clients, is start with a prior art search, right, try and understand the viability of the invention that you have brought to us, and trying and understanding whether or not it is patentable or not, right. Again, very important, not, it's, any invention will not be new. to be patented, any invention has to be new, unique, non-obvious, and so on and so forth. But it will not be new if any info about your invention is public knowledge. Very, very quickly, I'll give you an example. Like, founders are very, very lured into, the glory of and the glamour of starting a startup. And which is why sometimes, in that greed of giving a very nice interview in a magazine, you actually reveal a lot more than you should, right? That is also something that can actually create troubles for or restrict the viability of your own invention in getting patented. There was a client that I had who was basically the inventor of an equipment which was to be used in the textile industry. He went to Germany for an exhibition, and very enthusiastically he put his machine for exhibition. And now what we found out was that there is a German company that actually understood the know-how, figured it all out, and now is filing for patent claims for that invention. The German company is filing for its patent even in India, to get rights in India also, right? So these are some of the nuances that you have to be careful about. Trademarks, most of you probably would know, they are marks, logos, shapes and colors, in the way that they look, can be trademarked. They can be registered or unregistered, but I would say that with registered you have better rights and better protection, so to speak. They can be generic. There can be several types, right? Arbitrary, coined, basically coined would be the in this order. The coined or the arbitrary ones are the ones that are the most likely to get trademarks. Say, for example, things that don't mean anything, right? Adidas, right, is a coined term. It means nothing, right? So it is more likely to be protected. But that's again something that you'd probably need a lawyer for, and which is why it's important to actually have these things recorded, or be attentive to. Very quickly, data protection. The reason why I usually talk about this is because nobody talks about it. We as service providers, or as founders who are providing a product, in one way or form, you are retrieving data from your end customer, right? And this is personal data. This data is basically probably their name, their address, their age, payment details, and so on and so forth, right? um, you would probably know or not know, I don't know, but in the news it has already been made public that new data protection act has come very recently, in August 2023 itself. And the Indian Parliament has passed it in August 2023 with 10 months or so in implementation. They have not yet specified what the effective date of this act is going to be. But basically, the act applies to any kind of personal data maintained in digital form. And the processing of this kind of personal data is also governed under the act. If the processing of data is happening outside of India, and if such processing is in connection with goods or services that are offered in India, right? And long story short, I would just say that a lot of you, if any of you are fintech founders or startups working in the fintech industry, this is something that you should be aware of and be wary about, because you are anticipated to experience some of the most notable compliance impacts, right? There are like very, very stringent regulations. Something that I would like to actually highlight is the part where fines are concerned, right? Obviously there has been a lot of talk about taking free consent. The consent has to be free, specific, extremely clear and specifying the purpose for which you are taking all this kind of information, right? Failing which, the fines are gregarious, right? They range from some, for different activities, they range from 200 250 cr to 500 cr, right? And this is something that's important for startups to know. Of course, government has given some exemptions and some reliefs also to startups, but so long as you are aware of the fact that you are taking some or the other kind of personal information, and as many times, when we make terms and conditions and privacy policy for my clients, we try and actually tell them that every time a customer hits I consent, you know uh, eventually it's going to be beneficial for you if you actually keep a record of all those I consents, right? Like, where is that consent taken, right? There's nothing for you as a startup to rely on if you have not kept a record, right? And which is why data sharing, data protection is extremely important. Last but not the least, especially with fundraise and the legal jargons around it, I would say that it's important to understand what kind of investment instruments exist, right? So there's something called OCD, CCPS. You might be under, having only a limited idea about the kind of investment instruments that exist. But sometimes founders don't understand the difference between a convertible debt option and any other plain equity. There's currently a founder that's based out of Ahmedabad and whom I'm advising, and they have an OCD investment instrument, but the exit clause, as I said, has certain tricky variants to it, because of which they were under the impression that this is purely debt, right? Whereas it is uh, a convertible instrument. It is supposed to compulsorily convert into equity or shares, right? Rights and obligations, as I covered in the first few slides, control is something that I want to denote via rights and obligations. What kind of rights are you giving to the investor in your company is a very, very important and crucial aspect, because it goes on to the day-to-day operations of the company also, right? Prepare for due diligence, keep all documents in place. For that, have those documents in the first place, right? Like your foundational documents, just so that you can present and be ready for due diligence as and when time, as and when the time arises. Try and understand if the investor who's interested in you is the right investor for you at this stage, right? A lot of people, what they don't understand is, they don't actually have a clear alignment with the investor on how the company is going to grow, when is it that the company is going to be able to give them an exit, and any kind of expectations that the investor might have, right? So it's important to understand whether that rhythm, whether that alignment with the investor you have or not. Very quickly, takeaways. During incorporation, I would say keep it simple and organized, right? There are a lot of administrative as well as non-administrative processes, but as long as you understand them, you'll know how to keep it simple and organized. With co-founders, I would say that dealing with equity split, you need to have the foresight of the future, because this generally also takes care of all the future disputes or adversarial situations that you're going to be into, and which is why you should consider vesting, right? The concept of vesting. Have the paperwork done neatly and document everything. If it means documenting, a certain type of IP that forms or does not form part of the startup, then do that. Have the most foundational set of agreements in place, some of which we already, went through. Founders are also employees and have, which is why have all employees sign a certain kind of IP assignment and, confidentiality and invention assignment contract, which the founders also should be bound to. IP is important. Owning it is most important, which is why register it, right? Take the pains to understand what is applicable for the IP that you are building, whether it's a copyright, whether it's a patent, whether it's a trademark, whatever it is. Seek legal assistance to know more and decide in a better way. Data is gold, but looking at a few hundred crores in penalty can make it all go away quickly, because having not known that you might be under a purview of some kind of act that governs or restricts the way that you process data, specifically personal data, then that's something that actually will be troublesome. You must be a really really hot company, and maybe you'll be able to raise money very quickly, but be aware of the terminologies, as I said. Investment instruments, right? Trying and understanding what reserved matters are, what does tag along, drag along, rofo, all of those things mean. Get a lawyer who's into the startup space and try and understand and take those decisions that in a more aware way, right? Check for investor alignment and common investor requests, right? What is general, right? Is it okay to actually have the exit obligation also on the founders? That's when a lawyer would step in and would tell you that no, maybe not, right? So that's about it. I'm sorry, I basically I feel I've bombarded you all with a lot of jargon and a lot of concepts, but I feel that it's just an effort to actually help you be more aware and take decisions in a way that is not from the point of ignorance, but from the point of awareness. If there are any questions that I can help answer, then please let me know. These are my contact details, and thank you very much for listening to me.
Thank you so much, Khyati. That was a very informative session. Thank you so much. Thank you to everyone over here for attending this session.
I have a small question. Can I ask?
Sure.
Yes, please.
Khyati, I have a website. Mine is a D2C brand. And in order to have a payment option for the website, it is mandatory to have that refund policy, delivery policy, and stuff like that, terms and conditions.
Right.
So for those things also, do I need to contact a lawyer or take a sample format from Google and keep it with changing it as per my, my company, the number of days and things like that?
I think it's a great question. Ideally, if you want to build it right from the ground up, I would say that consult a lawyer. Generally, what might be applicable to others and taking something off Google might not be very, very helpful, because eventually there might be other hidden policies that might not be public for that particular brand, right? But they can always rely on those if they run into a dispute, but you may not, right? So while to start with it's okay, but I would say that not only it's a copyright violation because you're using somebody else's material and changing terms and brand name for your own ease and convenience, but also in the long term it probably might hurt your prospects of customer engagement, the way that you engage with customers and what applies and what does not apply.
Okay. And are there any players like that who would, who can just help on the need basis instead of, continuous engagement? Is your company like that? Or you would require long-term, association with the company?
No, we work both ways. So it's both project to project as well as on a retainer basis for a year-long project also. So whatever is suitable to the founders, we work with them. Although a long-term engagement helps us get to know the business more and better. But we are pretty flexible that way.
Okay, great. Thank you so much.
Any other questions?
Hi, Khyati. Can I ask a bunch of questions?
Sure, shoot.
Hi. Firstly, thank you for this very knowledgeable session. I had a bunch of doubts if we have time. My first question was regarding the exclusive involvement clause that you talked about for the engagement with employees. So, what if an employee is not engaging in any other employment opportunity per se, but they are, working towards building their own startup in a very non-related field, and they have not got their startup registered. So, like on paper, they are not director or founder or anything. So, does this situation also uh, can be termed as a violation of the exclusive involvement clause?
So long as you have an exclusive involvement clause in your agreement, right? I mean, nothing is a violation until it's meant to be, a rule for the company policy, right? So long as you have something within your company that says that the following set of, or the, for whoever you are, whoever is on the payroll of the company is exclusively expected to work with the company. I think that after that, any kind of engagement outside, even the knowledge of it should be, brought to attention and be sat down with that particular person and told them that, look, we you have to basically make your decision now, right? Because eventually, it's not registered now, it would be registered later. Eventually it's only going to come and be a violation anyway, right? But my idea was more from the point of view of incorporating that particular requirement as a clause in your employment agreements, which I feel most startups basically don't. I mean, they take it just like it's assumed that, oh, of course, like, yeah, I mean, we are hiring someone, they are supposed to be exclusively involved with us, right? But with startups, you have to like spell it clearly, right? So, because the people that you are going to hire are also not going to be extremely experienced people to know a certain level of professionalism, right? And which is why it's important that you have it.
Got it. My second question was regarding the patent process. So, typically, how much does a design or utility patent cost to get? Just to give some context, I am the co-founder of Mine Electric, and we are building an EV motorcycle with a new battery technology. So it's a very technology and hardware oriented startup. And we right now have just for the battery technology, which is our core IP, we have just built the prototype. So should we wait for like developing the full product and then applying for patent, or can we is it possible to apply for it at this stage itself?
See, it depends. A lot of people who come to me, I would rather say that, you have a lot of knowledge out there already, right? If you consider that a certain part of it's okay, it does not matter, first of all, to answer your question, what stage you are at, right? As long as you have been able to very nicely articulate what part of the entire invention is actually inventive according to you. Right. So even if it's at the prototype stage, if you are confident enough to actually pinpoint a very, very tangible aspect of the invention that you would like to get patented or protected in whatever form, then is when we can actually start the process and identify costs and whatever it means. But usually what founders do is that, A, they try and identify and articulate what is that inventive step. Two, they verify it against all the public knowledge that they already can take from the internet, right? There is Google Scholars. You try and identify that, okay, this particular aspect of your technology, who else has done it, right? What is already protected? And that's how you can actually rule out, possibilities and get to a more defined, precise, and a sharper part of the invention that you want to get protected.
Understandable. And also you talked about due diligence. So I don't know, I was just reading about this on Google. Is there something called a technology due diligence as well, which the investor might want to
Oh,
maybe?
absolutely. I think it might not be actually testing the product themselves, but in the VCs in the Bay Area have these validation partners, right? That I have often come across that validate your product on the technology aspect, right? So if that's already a trend outside, but in India it's definitely like, if investors are skilled in the domain itself, they know when they're actually grilling you. So most of that due diligence part and vetting the technology would happen when you are pitching to them, and trying and demonstrating the product to them, because I think that's the core, right? That's the key aspect behind, I mean, that's the reason why they are investing in the first place.
Right. So is there anything we need to do at the end of the startup to prepare for this technology due diligence process? Because let's say for others, we can, keep the documents at one place and all of the other things.
I think essentially it means just like, making or creating a stellar product, right? There is no documentation that you can keep in place. What you can do to actually show preparedness to an investor is that in addition to creating a very, very fine product, you are actually having all these, you know allied documentation around it, that bind the employee, that bind the founders, and the way that generally your corporation is run in a way that instills trust in the investor's mind, that hey, the founders are committed, they obviously have a great product that I want to invest in. But in terms of preparedness and getting in investors money faster, they have already had the governance up to date. And that's all. I don't think that in terms of technology due diligence there might be any actual product related documentation. It's just the product itself that goes on to verify how amazing you are, or the startup is.
Yeah. Thank you so much, Khyati, and we'll definitely reach out to you via mail as well.
Sure, my
Thank you.
pleasure. Anything else?
Hello, ma'am. Good evening. Am I audible?
Yes.
I'm Meenakshi. I am basically a 20-year-old student. I just own a startup which I've been developing for past 2 years. So I have just two questions. So I am a college student now. So to reach out and get more opportunities, because we're not full-time working in the startup, we expose the ideas to a lot of competitions, a lot of college events and so on. So how does the IPR? I have read so many times like IPR gets violated, and we lose some of the rights and all. So how do we enable to protect it, but at the same time do not restrict ourselves to sharing it with someone else for opportunities?
I think it's about understanding how much you want to reveal, right? So especially when you have a proper full-fledged startup, the same thing arises not in the context of, competitions or hackathons or, events. The same thing happens when you are pitching to multiple investors, right? A particular investor also would have at least 3 to 4 meetings with you, and those would be staged, right? The first time when you go to meet, you need to have a very, very small concise deck, right? Is what I tell my founders. The second time you go with a certain level of proof of concept, right? And the third time that you go with a detailed deck with all the core IP there, before which you have an NDA signed, right? That's the same thing that applies when you actually go for competitions like hackathons or something like that. Mostly, I mean, depending upon the type of competition and the type of people involved, you would not be required to actually reveal your core IP as part of participation in that competition. So say, for example, if there is a competition, then you're not supposed to actually reveal your core IP. You're just to you're competing with others to provide a solution, right? That's what we call a hackathon, right? But I would say that how much in such circumstances, or I mean, I don't think that in competitions or in such events you are going to face that situation. But even otherwise, to generally answer your question, I would say that first test the waters, try and understand that who are you talking to, what is their background like, right? And reveal only as much as you are expected to. To give you a very fine example, I'm currently mentoring two founders out of IIT Jodhpur, and they are basically like they got a fellowship, and the fellowship agreement itself had a clause that whatever you do during this 1 year of fellowship that the university has given you, whatever IP you create belongs to the company, belongs to the university, right? It's a very blanket clause, right? It's a very, very wide clause saying that whatever you do would belong to the university. So that is when you would actually need a lawyer to push back, come with the kind of ways in which you do not allow the university to know a lot more about your startup idea, right? Use different types of, don't use the resources of the university or the institute to actually build your idea, right? Do it on your own time, and so on and so forth.
Ma'am, so also talking about the level of different startups of, I mean, people who are developing in my age or below my age. So is it necessary for them to have a legal advisor or a lawyer, or can we also get into services like how you're offering, like you've been a personal legal advisor for the May student startups. So what is it more advisable of?
Sorry, I didn't understand. I mean, are you asking that is is age a function of getting legal help?
Yes, I'm just trying to define or make it a true or a false statement. That's all.
It doesn't depend. I mean, you might be 18-year-old, 20-year-old, or whatever year old. Your ability to get a lawyer to advise you and support you, in making a few decisions has nothing to do with age. And there are a lot of startups that I engage with on a mentorship basis, right? So we basically meet 1 hour a week, and we try and actually work our ways through the bottlenecks that the startup is facing. So it does not actually mean that you're basically like, you have to be of a certain age to get legal help and support and mentorship. I think that with younger girls, I would say that just ask and you'll get help, right? You just need to ask, and there will be, AFH, for example, is a terrific community that basically will help you with whatever you need, whenever you need, with guidance, with mentorship, and so and so. If you and that's all that you need to have, nothing more.
Sure, ma'am. So can we get in touch with you like through mail or something for the same?
Oh, sure. Just I my details are on the screen. I hope you can
Yes,
see
ma'am.
them.
Noted it down. Yeah, sure. Thank you so much, ma'am. Ram.
You're welcome. Anything else? Vibha, you're on mute. I'm sorry.
Sorry. Yeah, I think we are done with most of the questions. So, of course, in the interest of time, I think we should, end the session for now. So, thank you so much again, Khyati.
Vibha can't hear you.